So this video is about the exercise of powers when there are multiple executors named of a will or trustees named of a trust. I'm Paul Rabelais. I'm an estate planning attorney. I get the question all the time. Paul, if we're writing a will and naming executors, or Paul, if we're creating a trust and naming trustees when we're not around, if we name more than one, do they have to work together? Can they work independently? Great question. So in Louisiana, it's really unique because when there's a different set of rules for executors than there are for co-trustees. Let's jump right in. So let's go through the executor part first, and really our law addresses it as succession representative, because we also are talking about administrators that are appointed by the court, but now let's just leave it as executors. So our rule says if a person writes a will and they name more than one person as executor, that would be co-executors, might be 2, 3, 4, 5. Then if there are several executors named, then action taken by them shall be taken by them jointly. So if you have 3, 2 can't outvote the other. If 2 want to sell a house for $300,000 and the one says let's hold out for $350,000, it ain't gonna sell, because you got to have all of them taking action jointly, unless of course the will provides otherwise. The will could say I'm naming 3 co-executors, but any 2 of them may act. But if the will doesn't provide for that, all 3 of them must act jointly, or 4 of them, or whatever the case may be. Let's move over to trusts. And so trusts, we have to break it down into two scenarios. The first scenario is there are 2 co-trustees. So powers conferred upon 2 co-trustees shall be exercised by both of them unless the trust instrument provides otherwise. So same as the executors, 2 executors, 2 co-trustees, they must act together. The legal document can provide otherwise if you want to enable one of them to act independently of the other. Now, the difference comes in is when you have 3 co-trustees names. If power is conferred in 3 or more co-trustees, those powers may be exercised by a majority of the co-trustees, of course, unless the trust instrument provides otherwise. So if you name 3 co-trustees, 2 can outvote the other. If you name 3 co-executors in your will, must take all 3 for there to be action. If you can be on top of this on your way into going to see the estate planning attorney, they're going to be impressed. But just know it happens a lot because parents often, they don't want to appear, show favoritism to one child. So they say, well, we have 3 children. Let's name all 3 to have those powers. And so you really need to understand what our Louisiana law says. Different when you're appointing 3 executors of will than 3 if you're appointing 3 co-trustees of a trust. Understand that, you'll be well on your way to making the right decisions to get your estate, legal affairs in order. I'm Paul Rabelais. Make sure you go leave a legacy. Take care.